Yes.
So, my lord, level playing field, when we talk about the level playing field, my lord, if I have to understand level playing field means every party should get equal political contribution, that can never happen. Mr. Sibal would have 10 matters, somebody would have only one matter. Nobody can argue that there should be level playing field, everyone should have 3 matters. That every political party will have to rise to the level that they get more trust and they get more contribution. But if the level playing field argument is attached to the fact that the party in power comes to know about it, well, this is the way in which it can be taken care of, and both apprehension and the public interest can be balanced. That even party in power will not come to know. Now, my lord, at this stage, my lord, I would like to show how, my lord, this scheme operates to satisfy your lordship's conscience. Because yesterday I found, my lord, your lordship's valid concern that it is possible for the ruling party to know, but rest of the parties would not know. My lord, as I was told by the chairman, that it can't be discussed publicly. Whatever can be discussed publicly, my lord, I have a separate thing. On my request, the officials of the SBI are here. Lord, I would request your lordships, if your lordship would like to know the entire semantics, how this system operates and how there are separate silos which cannot be breached, and you have to go into one system, you have to go into another digital system, you have to go into third digital system, leaving your footprints. If there is a court order also, then your lordship would be satisfied that it's not as if that a finance secretary calls the managing director of SBI कि हर 15 दिन मुझे भेज दो किसने कितनी कौन सी पार्टी को कितने पैसे दिए. It's impossible. It's that foolproof a system. Your lordships can hear them in chamber. But right now, my lord, I may show this, my lord, what is the system to satisfy your lordship's conscience. It's not, my lord, as if that I go and deposit some amount in the bank and tomorrow the senior official of the bank calls the branch manager, what amount Tushar Mehta has deposited. He will just see and say that he has deposited 10,000 rupees. It's not that simple. It cannot be that simple. When we are ensuring confidentiality, and when confidentiality is the heart and soul of the scheme. Please, my lord, allow me to share this, my lord, screen share this. My lord, there are extra copies also. I have emailed also. But I have not, my lord, I have missed purposefully. I have decided, it's my, my lord, call that I have not said many things which the chairman also rightly feels and I also feel should not be made public. What is, how we maintain secrecy, my lord, can't be a public debate. That's all. Because by definition, it has to be confidential. Assure your lordships that every judgment which I have quoted, I'm not going to cite. I would be very naive if I quote judgments which I know your lordships have read.
The citation and the paragraph so that
I have quoted that.
Oh, I see.
So I'll say that kindly read it. I'm not going to read except few judgments which I'm unable to resist that.
You may just flag those. That's all for us.
Yes, yes, yes. Lord, this is, my lord, the copy is given.
Leave yourself a little time to deal with the challenges to the amendments to the statutes. Huh?
These are, my lord, the objects.
Right, right. We have now covered the scheme.
No,
I'm just saying that since you have an hour to conclude, give yourself a little time to deal with the challenge to the statutory amendments.
That's what, my lord, my answer is. One line answer. The statutory amendments are to ensure that this scheme can be framed and can be operated. That's the purpose of the amendment. There are no separate objects.
That's okay. And you have really covered the reasonableness aspect as well.
There are corollary.
Yes.
To, my lord, the scheme. First, it came under the Reserve Bank of India Act that government can formulate the scheme. That is challenge to the Reserve Bank of India Act. My lord, now by itself is not illegal.
Just wanted to ask you this. It may not be very relevant for but just to understand the legal framework. Why was it necessary to amend the RBI Act actually to bring in the scheme? I mean, as a matter of law, what was the reason?
Lord,
we just have that. I have, in fact, it opened here at page 31 in your written submissions. Section 31 says that no person except the Reserve Bank of India or the central government can issue a bill of exchange, promissory note, or engagement for the payment of money payable to be to bearer on demand.
Well, it would be a bearer bond, my lord, because
The reason seems to be, and that's RBI's report, that only central government and RBI is permitted under that section. The issuance is being done by SBI now. So
no, that's not the idea.
Yes, so it's somebody else which is being permitted, and that's one of the reasons which the RBI's letter also, which I think Mr. Bhushan showed to you.
Lord, there is nothing turns on the, and you will not succeed or lose on this. But, my lord, the purpose was,
31 may have word. 31.
please see, my lord, one, this was to make an exception to one. But your lordships would mark that if I try to breach the confidentiality system, it would lead digital footprints left. It's not, my lord, as if my learned friends were it's not even oversimplification, something less than that you can just see in the light and you get the number and you can compare it with the political party. It's not like that. If necessary, my lord, I'll come to that. My lord, what is the system? It leaves its footprints in the digital format which cannot be erased. Please read and kindly see, my lord, the intention of the government and, my lord, the bona fides of the government. Anyone not complying with or committing breach of this confidentiality, your lordships may say, would be criminally liable for criminal breach of trust or whichever other provision, my lord, which is applicable. I have not examined, my lord, from IPC point of view. So this takes care of one thing, that you have the biggest public sector bank, the assurance of the chairman of biggest public sector bank with your lordship's direction that any breach will be visited with penal consequences. Now, my lord, second, and that's where my lord Justice Khanna's very valid concern, my lord, was expressed. So far as court is concerned, my lord, I don't think anybody has disputed. My lord, somebody were to go to the court. My lord, for example, just to answer my lord Justice, Chief Justice's query, that there is a quid pro quo. Suppose somebody goes to the court that this gentleman has given money as per his bank statement or as per his account, or this company has given 50 crores to some political party as per his statement. Kindly listen to this. This is interesting, my lord, how the scheme works. That this company has given 50 crores to some political party, that is reflected in their balance sheet, which is to be made public as per the company's law. Immediately thereafter, the one particular government has given him a contract worth 250 crores, and therefore I suspect he has to give reasons. He can't rush the way PIL petitioners are rushing, but he can say that there may be a quid pro quo, and the court is prima facie satisfied that yes, there may be. Let us see whether those 50 crores has gone to the party which is in the government who has given the contract. That is why under the court's order, it will have to be decoded, which has a very serious and complicated process. It is not easy even under the court's order. Now the concern of my lord Justice Khanna, and very right concern, that upon registration of a criminal case by the law enforcing agency, my lord, the concern would be that you register a criminal case and ask SBI that give me the details. That was, my lord, the concern. Your lordships would recall in Aadhaar judgment, there was a similar provision. And your lordships have read it down to me to say that when investigating agency wants this, it can get only if there is an order of the court. Kindly put that layer by reading it down. Look, kindly see, my lord, the bona fide is, the purpose is not that the party in power knows what is paid to whom. The purpose is not that this is to be used for the purpose of penal persecution.
That there's an authority or the legal
There
power
is
to
a
issue this.
statutory backing to the scheme. That's
To be confronted with a legal
That is
challenge.
a purely executive act. Minus,
yes, otherwise it would have been challenged as an
the
executive act.
legislative backing.
It could have been said that it's a bearer bond, only the RBI can issue, etc., etc. And therefore, my lord, with a view to empower the central government to come out with this policy.
And it would otherwise fall within the broad definition of a bill of exchange.
Exactly. Or a bearer, my lord, instrument. They say payment of money payable to bearer on demand to borrow.
Or engagement for the payment of money payable to bearer on demand. Engagement is very broad.
And one,
Therefore, that
Lord, subsection
three-
1, first line,
Yes.
first line, subsection 1, no person in India other than the bank, that is RBI, or as expressly authorized by this act. So this is the authority given to the central government. That's all, but to give a statutory backing so that it doesn't remain an administrative instrument.
All right. Now what next, Mr. Solicitor?
Yes, my lord. Now what I'm reading is on the screen, my lord. I have shared, my lord. Nothing to hide, my lord. I have said that the chairman has, my lord, one should trust the system, etc. my lord. Third, without elaborating, however, a brief description of the system can be provided to the court to satisfy the court's conscience that it is impossible for anyone, including the incumbent government, to breach this system without A, the contingency contemplated under clause 7.4, or B, without leaving a digital footprint and trail if someone tries to breach into the system over and beyond the mandate of clause 7.4. The process for providing donations through electoral bond has two separate compartments, and they are issuance of bond and redemption of bond. Correct, my lord? Your lordship knows. I leave it at 3. In order to maintain confidentiality of the process, the data that is populated at both ends is recorded in a limited manner and not populated in the central databases. It doesn't contain the name of the donor. My lord, I can purchase it from Assam, Guwahati, because that is one of the SBI branches, and pay in Delhi to Indian National Congress or Bharatiya Janata Party because their office is situated here. They can have their authorized account practically, generally in Delhi, but anywhere in the country. And I can purchase it from Delhi and pay to Trinamool Congress in Calcutta. They would have their account in Calcutta. Now 4, separate storage and separate collection of data ensures that there are no direct linkages maintained in the database between the donor details with donee details. 5, the register which is maintained at the designated branch, please mark this, which issues the bond does not maintain the register with names of the purchaser or the donor. So if I go and buy a bond worth 1 crore, the register would only say one bond issued.